This is Barry Zalma on insurance. Today I'd like to talk about the effect of an insured's breach of a material condition to a policy of insurance. As early as 1897, the Supreme Court of Pennsylvania, in a case called Early v. Hummelstown Mutual, held that it is beyond all question that a plaintiff had forfeited the right of recovery on his policy at the time of a fire by breaches of material conditions of the insurance contract. A provision forbidding or limiting additional insurance is intended as a condition upon which the company assumes liability, and the law is well settled that upon the breach of such a condition there can be no recovery upon the contract in which it is contained, whether a condition precedent or subsequent. The courts of Missouri, among others, in a number of decisions, have held uniformly that a stipulation restricting concurrent insurance is a warranty presumed in law to be material to the risk, and that any substantial breach of such a warranty ipso facto would work a forfeiture. Under Louisiana law, an insured's compliance with the provisions of an insurance policy is a condition precedent to recovery. Therefore, an insured's failure to cooperate may be held to be a material breach of the policy and a defense to the insured's lawsuit on the policy. More particularly, an insured's failure to submit to an examination under oath, or its refusal to produce requested documents, may violate the policy's cooperation clause. A failure to cooperate precludes recovery when the insured engages in a protracted, willful, and apparently bad faith refusal to comply with the cooperation clause. The failure to appear for a duly scheduled independent medical exam or an examination under oath, both conditions precedent to recovery, voids no-fault coverage under the policy from its inception. The failure to appear for an EUO that was requested in a timely fashion by the insurer is a breach of a condition precedent to coverage and voids the policy. In Motiva Enterprises v. St. Paul, a 2006 decision of the Fifth Circuit Court of Appeal, it found that Texas law requires a finding of prejudice for denial, even when an insured breaches a material condition of the policy. The Fifth Circuit noted that the Texas Supreme Court's decision in State Farm Lloyds v. Maldonado, where the issue of prejudice was never mentioned. In Maldonado, State Farm tendered a defense with a reservation of rights to its insured, who had been sued for defamation by a former employee, Maldonado. When State Farm would not pay Maldonado's settlement demand, Maldonado and Robert entered into a private agreement in which Maldonado discharged Robert from further personal liability for Maldonado's damages. Robert, no longer having any incentive to contest the defamation claim at trial, failed to actively defend the claim through his attorney provided by State Farm. He did not present any evidence, cross-examine any witnesses, or present opening or closing arguments. The trial resulted, as was obvious, in a verdict in favor of Maldonado. State Farm denied coverage and contended that the trial constituted a breach of the actual trial condition of its insurance policy and relieved State Farm of its duty to indemnify. The Texas Supreme Court agreed, holding that because State Farm agreed to defend Robert under a reservation of rights and Robert failed to satisfy a condition precedent to the insurance policy, Robert cannot sue or recover under the policy, and as a result, the plaintiff Maldonado, who had given up his right to sue Robert in hopes of making a lot of money from State Farm, took nothing from its suit. The case resulted from a rule of law in Texas regarding the results of a failure to accept a settlement demand that is less than the policy limits. The insured will make what is called a Stowers demand over a case called Stowers Furniture versus American Indemnity, a 1929 decision of a Texas court. A Stowers duty is triggered by a settlement demand. When 1, the claim against the insured is within the scope of coverage, 2, the demand is within the policy limits, and 3, the terms of the demand are such that an ordinary prudent insurer would accept it, considering the likelihood and degree of the insured's potential exposure to an excess judgment. The Fifth Circuit noted that the Texas Supreme Court held in Hernandez versus Gulf Group Lloyds, a 1994 decision, that an insurer may escape liability on the basis of a settlement without consent exclusion only when the insurer is actually prejudiced by the insured settlement. The court based its holding on general principles for interpreting contract law and observed that when one party to a contract commits a material breach, the other party is discharged from any obligation to perform. In determining the materiality of the breach, the court observed that it must consider the extent to which the non-breaching party will be deprived of the benefit that it could have reasonably anticipated from full performance. A panel of the Court of Appeal in Texas recently applied Hernandez and held that Texas law requires that an insurer show prejudice resulting from the insured's breach of a condition in the policy to defeat the insured's claim to policy proceeds. It appears that in Texas, if there's a breach of a contract before the insurer can safely deny coverage, it must have sufficient evidence to prove beyond a preponderance of admissible evidence that the fact of the settlement prejudiced the insurer's rights. Although Maldonado never mentioned the word prejudice in its decision, it is clear from the facts that State Farm Lloyds was prejudiced by the actions of its insured, whose lawyer appeared for trial and did nothing. It's not a trial if you just give in and admit everything. Similarly, in Stellar versus State Farm General, a 2007 decision of the California Court of Appeal, it held that an insurer owes no duty to defend its insured in a defamation action if the insured's allegedly defamatory statements were not accidental. Defamation, which includes libel and slander, is an intentional tort, which requires proof that the defendant intends to publish the defamatory statement. The very nature of defamation precludes the conclusion that it can occur accidentally. However, if an insured throws someone into a swimming pool intending to get the other person wet, but by mistake does not throw hard enough and so the person lands on the pool's cement step and suffers injuries, the intentional act exclusion will not apply because the injury was not intended. The U.S. Supreme Court faced with a condition that provided, quote, "this entire policy, unless otherwise provided by agreement endorsed hereon or added hereto, shall be void if the insured now has, or shall hereafter make or procure any other contract of insurance, whether valid or not, on property covered in whole or in part by this policy," close quote. Concluded, the Supreme Court stated, that by reason of the breach of the condition, the policy became void and of no effect. The Supreme Court noted, however, that the breach could be waived by the insurer. Mr. Justice Strong, dissenting on the finding of waiver, said, "Besides the importance of such considerations to the parties immediately concerned, in business transactions, the community at large have a deep interest in the welfare and prosperity of such beneficial institutions as fire insurance companies. It would be very unfortunate if prudent men should be deterred from investing capital in such companies by having reason to fear that conditions which have been found reasonable and necessary to put into policies to protect the companies from faithless agents and from dishonest insureds are liable to be nullified verdicts based on verbal testimony." Close quote. Any warranty that must be strictly satisfied will serve as a condition precedent to an insurer's obligation to pay. Warranties are effectively policy stipulations that function as conditions on an insurer's obligation to pay a loss. In insurance law, it is more precise to refer to any condition that must be satisfied after the risk of loss attaches as a condition subsequent, to distinguish it from a condition precedent to the policy's being effective. By using the term condition subsequent to refer to any insurance policy condition that applies after the risk of loss is attached is different from its meaning in a non-insurance context. Conditions subsequent are less common in non-insurance contracts because they can permit a party to avoid its obligation after its duty to perform has been triggered. A true condition subsequent is the equivalent of a post-loss condition in an insurance policy, such as after a loss has occurred, an insured's failure to comply with a notice of loss provision may result in the insurer's avoidance of liability. However, for insurance policies, the term condition subsequent comprises both pre-loss conditions, that is, such as to keep records, to which the contribute to the loss standard applies, and post-loss conditions, such as provide notice of loss, to which the standard usually does not apply. A vacancy clause in an insurance contract is not an exclusion. It is a condition subsequent to which the contribute to the loss standard applies. And if the property is vacant, there can be no coverage for the loss because of the breach of that condition. When a fire damaged an insured's grain elevator and the insured assigned his interest in the insurance proceeds to the plaintiff before the claim for the first fire was processed, the insured set fire to his grain elevator. The district court ruled the insured's fraudulent act did not prevent the assignee from recovering insurance proceeds for the first fire. If there is no breach of condition precedent or subsequent at the time of the loss, then a breach of condition subsequent after the loss will not void the policy unless the fraud or breach pertains to the loss which already occurred. This was the Ninth Circuit's decision, Cecilia versus Safego, a 1992 decision. Hawaii courts have developed a solid policy of ruling against the forfeiture of insurance coverage in the absence of specific exclusions, fraud, or other serious dereliction on the part of the insured, if such conclusion is not patently unreasonable. The law in Hawaii is in accord with the modern trend in requiring that insurance coverage be upheld unless the insured's breach of a condition subsequent can be shown to have contributed to the loss or in fact made the insurer's risk more hazardous. This was stated in a case called Avemco Insurance versus Chung, a 1975 decision of the District Court District of Hawaii. This video was adapted from my book, Zelma on Insurance Claims, Part 102, 3rd edition, which is one part of the 10-volume treatise, Zelma on Insurance Claims, all 10 now available in their 3rd edition from Amazon.com. If you found this video to be interesting or useful to your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel and my Rumble channel, clicking on the like and Rumble buttons as you do. And also subscribe to my blog, my Substack publications, and my locals community. Thank you for your attention.